Trump Legal Cases Daily Digest. January 15, 2024. Hello and welcome to News Media Hans Daily Digest. This week Trump's legal calendar focuses on the E. Jean Carroll defamation case, Tuesday, Maine ballot disqualification appeal written decision, Wednesday, Colorado SCOTUS 14A, last day for Trump brief and last day for amicus curiae briefs, Thursday, Probable DC Circuit merits decision in Trump presidential immunity, Friday, Maine 14A, last day for Trump notice of appeal filing to the decision of the Superior Court, Saturday. Stay tuned for more developments on these cases. Now, let's get started with a surprise from Trump legal team. Joe Tacopina withdraws from Trump's legal defense team. In a significant shakeup for Donald Trump's legal defense, attorney Joe Tacopina has withdrawn from all matters related to the former president's legal battles. Tacopina, who accompanied Trump during his plea of not guilty to charges related to hush payments, confirmed the withdrawal, stating, "I withdrew on all matters." This move comes as Trump faces allegations from the Manhattan DA's office that he engaged in a scheme to manipulate the 2016 election through hush money payments. Tacopina, known for his extensive trial experience, was a key figure in Trump's legal team, having represented him not only in the hush payment case but also in the civil defamation and battery case brought by E. Jean Carroll. In a letter to Judge Juan Merchan, Tacopina formally notified the court of his withdrawal, leaving lead counsel Susan Necheles at the forefront of Trump's defense in the ongoing legal proceedings. This development raises questions about the dynamics within Trump's legal team and the strategies they may employ as they navigate multiple legal challenges. The departure of Tacopina, a seasoned trial lawyer with a history of high-profile cases, adds a layer of complexity to Trump's legal defense, signaling a noteworthy shift in the legal landscape surrounding the former president. Trump faces new legal test as E. Jean Carroll defamation trial resumes. As the E. Jean Carroll defamation trial resumes, the spotlight intensifies on the narrow question facing a Manhattan jury: the financial consequences for Donald J. Trump over his remarks concerning the writer's rape accusation. This trial, distinct from the previous one, zeroes in on Trump's 2019 comments dismissing Carroll's claim as totally false. Despite a prior jury awarding over $2 million for the assault and nearly $3 million for defamation, this proceeding addresses the specific statements made by Trump during the explosive revelation of Carroll's accusation. The judge's preclusion of contesting Carroll's version puts Trump in a precarious position, limiting the scope of his potential testimony. Trump's unprecedented decision to attend and testify at this trial adds an extra layer of complexity, raising concerns of potential chaos. Carroll's lawyer, Roberta A. Kaplan, has urged the judge to impose restrictions on Trump's testimony, seeking assurance that he comprehends the boundaries set by the court. However, Trump's attorney, Alina Habba, asserts that such measures would be unwarranted and implies that the trial should not resemble a kangaroo court of a third world country. The impending legal battle underscores the contentious dynamics between Trump and Carroll, with broader implications for the ongoing legal challenges the former president faces. Against the backdrop of Trump's continuous attacks on Carroll, the trial not only delves into the intricacies of defamation but also serves as a stage for the clash between the two figures. Trump's strategy of persistent denial and counterattacks raises questions about the potential impact on his overall legal battles and the public perception of his responses to serious allegations. The trial's outcome holds significance not only for the immediate financial repercussions but also for the precedents it may set in addressing high-profile defamation cases involving public figures. Donald Trump's persistent attacks on E. Jean Carroll continue amid legal proceedings, with recent remarks directed at Judge Kaplan after the denial of a trial delay. Trump, criticizing the judge as a crazed, Trump-hating judge, accused the trial of being an election interference witch hunt. Legal experts, including Rebecca Roife and Ben Chu, contemplate Trump's strategy, suggesting it may be more of a public relations move than a legal one. The potential impact of a substantial punitive damages award is considered a means to curb Trump's relentless attacks. As the trial unfolds, the focus shifts not only on the legal intricacies but also on the broader implications for addressing defamation cases involving high-profile figures like Trump and their public relations dynamics. Trump allowed to testify in E. J. Carroll defamation trial. A New York judge has given Donald Trump the green light to testify at his own defamation trial, dismissing concerns raised by E. Jean Carroll's lawyers about potential disruptions caused by the former president's presence. Judge Lewis Kaplan stated that, if necessary, he could extend the trial to accommodate Trump's testimony on January 22. The trial, set to determine damages for Trump's defamatory remarks against Carroll in 2019, is a follow-up to last year's case where Carroll was awarded $5 million for battery and defamation. Carroll's attorney, Roberta Kaplan, had sought strict measures against Trump's attendance, citing concerns about his disruptive behavior, which was evident in his recent New York civil fraud trial. Despite the rejection of specific measures, Judge Kaplan pledged to ensure the trial adheres to legal standards. Carroll's legal team expressed apprehensions that Trump's potential testimony would aim to sow chaos and delegitimize the proceedings, emphasizing concerns based on Trump's conduct in previous trials. Strict guidelines have been imposed on Trump's arguments, prohibiting him from denying sexual assault or questioning Carroll's motives. Carroll's attorney suggested that Trump's likely testimony might lack feasible arguments within these boundaries, potentially serving a broader political strategy. In response, Trump's attorney, Alina Habba, dismissed these concerns as a desperate attempt to constrain Trump's defense, emphasizing his limited ability to defend himself under the court's prior rulings. Despite rejecting specific measures, Judge Kaplan assured that he would take appropriate measures to prevent circumvention of legal standards during the trial. Lawyer warns against Trump's potential disruption in upcoming defamation trial. As the defamation trial against Donald Trump approaches, attorney Roberta Kaplan, representing columnist E. Jean Carroll, cautioned Judge Lewis A. Kaplan about the potential chaos that Trump might instigate during the proceedings. In a letter to the judge, Kaplan expressed concerns that Trump's recent statements and behavior strongly suggest an intention to sow chaos in the trial, emphasizing the possibility that he might seek to testify and violate court orders. She recommended that the judge take preemptive measures, including warning Trump of the consequences of violating court orders that restrict the content of statements made by him and his legal team during the trial. Kaplan cited Trump's behavior in a recent state court proceeding as a potential preview of what might unfold during the upcoming trial. She noted that Trump's disregard for the judge's instructions and his statements about being an innocent man being persecuted provide insight into the disruptive behavior that could be expected. Kaplan urged the judge to require Trump to state under oath, without jurors present, that he understands the established facts for the trial and to issue warnings about the consequences of violating court orders. The upcoming trial will determine whether Carroll is entitled to additional damages for statements made by Trump in 2019 and immediately after the verdict in the previous trial last spring. Judge orders Trump to pay $400,000 for journalists' legal fees. Former President Donald Trump has been ordered by a judge to pay nearly $400,000 in legal fees to the New York Times and 3 investigative reporters, including Berkeley journalist David Barstow. The lawsuit, filed by Trump after the publication of a Pulitzer Prize-winning investigation into his finances, accused the journalists of conspiring with his niece, Mary Trump, to obtain confidential financial documents in an alleged insidious plot. However, the judge dismissed the case last May, emphasizing the protected nature of standard reporting activities under the First Amendment. Barstow, who now heads UC Berkeley's investigative reporting program, celebrated the ruling as a victory for press freedom and stated, "Donald Trump pays a big price for trying to silence journalists." In his decision, New York Judge Robert Reed defended the journalists' right to engage in legal and ordinary newsgathering activities, highlighting the essential protection provided by the First Amendment. Barstow, who spent 20 years at the New York Times and holds 4 Pulitzer Prizes, expressed relief over the judge's order, characterizing the lawsuit as frivolous and harassing. The legal victory underscores the significance of safeguarding journalists' ability to pursue investigative reporting without fear of legal repercussions, establishing a precedent that upholds the core principles of protected First Amendment activity.
Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.